Hello everyone, welcome to another edition of WYO2A Arsenal Roundup News. My name is Richard Espinoza, I'm your host. We are your primary source for Second Amendment news, whether it be here in the great state of Wyoming or every part of the United States. We keep you informed on Second Amendment issues, whether if it's good, bad, or ugly, whether if it will help benefit your Second Amendment rights or it will affect your Second Amendment rights. Good or bad, we report it to you. Please like and subscribe if you are a strong supporter of the Second Amendment and you believe in joining the fight. Please subscribe. Your subscription would be deeply appreciative. I also encourage those of you to follow some of my friends on YouTube. First, I'd like to encourage you to follow Stooch000, Don Porter. If you're looking for the right firearm, if you're looking for different choices in guns that you want to use for an everyday carry or for a home defense weapon, Stooch000 is the man. He will give you great, honest reviews. He teaches you how the firearm functions, teaches you how to field strip it, so that you know the do's and do nots of handling firearms. He also has his Sensible Prepper channel, which I encourage you to watch. He's definitely a fountain of knowledge when it comes to that. So I encourage you to follow. And I also encourage you to follow Jarrett from Guns and Gadgets. If you want to keep informed on what is going on, he's the guy to go to. He definitely keeps everybody informed on the legislations and the backdoor deals that our elected officials are doing. And he's the ultimate watchdog when it comes to keeping us informed on what is going on with our Second Amendment rights. And I also encourage you to follow Mark Smith from 4Box Diner. He is another fountain of knowledge. He's also the winner of the Gundy's Awards as one of the best Second Amendment influencers. He also has a lot of great deal of knowledge. Of course, he is an attorney. He's a Second Amendment right attorney, so I encourage you to follow him as well. And also John Crump. Follow John Crump live. John Crump is also a 2A journalist, so I encourage you to follow him as well. Well, today, ladies and gentlemen, I'm going to be talking something extremely disturbing. The state of Washington, and I say the name State of Washington, a state that's named after our founding father, our father of our country, George Washington. Disgrace his name in vain as the Supreme Court in Washington upheld their magazine ban, which is utterly, totally un-American, totally unconstitutional. And I'm going to get into the root and details of this unjust ruling made by the Supreme Court of the state of Washington. But again, there is hope, because this fight is far from over. Because already, GOA, the Second Amendment Foundation, which is a Washington base, also the Citizens United to Right to Keep and Bear Arms, which is also an affiliation of the Second Amendment Foundation, will also be involved. The National Association for Gun Rights, the Firearm Policy, they have every intention to drag this all the way to the Supreme Court in Washington, D.C. And what I'm going to read to you momentarily is utterly disturbing, the way that these judges think. Now, a lot of these judges are activist judges, especially the judges in Washington. You know, and I've brought this up before, that these judges have worked for gun control groups. Some of these judges have worked for the Brady campaign. They have worked for the Violence Policy Center with Josh Sugarman, the Southern Poverty League, even Michael Bloomberg's Every Town for Not So Gun Safety and Moms Demand Action. The majority of these activist judges, who are not rule of law judges, use their political bias to justify their ends and means of their decision that they make. And yet, it's named after, the state of Washington is named after our founding father. But worst of all, our nation's capital, named after our father of our country, outright pisses on our Second Amendment rights. So let's ask, what would George Washington say today? Well, I'm going to read you some quotes from George Washington, what he says about the Second Amendment, because he was also one of the co-founders who written the Second Amendment with Thomas Jefferson. So I am going to read you right now what George Washington said. He says, quote, "When the government takes away citizens' right to bear arms, it becomes the citizens' duty to take away the government's right to govern." Then it goes on to say, "Firearms stand next in importance to the Constitution itself. Firearms are the American people's liberty teeth and keystone under independence." Then it goes, also says, "Free people ought to not only be free." I'll read this again. "A free people ought to not only be free to be armed, but disciplined, but they should have the significant arms and ammunition to maintain the status of independence from any who might attempt to abuse them, which would include their own government." Well, George Washington would know something about that, because he lived under the rule of law of King George III. And he among all people knows that the King of England used civil disarmament to use oppression towards the people. Now, next I am going to read you about the state of Washington's decision about this court ruling, which is totally BS. And it goes to show you that these judges are activist judges. They're not real judges. And I've said this before, that judges are basically corrupt lawyers in black robes. They're nothing special. But a real judge base their decisions on the rule of law. So you got two types of judges. You got activist judges and rule of law judges. Well, I am going to read you right now on the decision that the state of Washington made in upholding its magazine ban. And I know a lot of you are going to be very disturbed on what I'm going to read to you, and you have every right to be upset. I know there's going to be a lot of you that's going to make you grit your teeth. It's going to get your blood pressure going. But if you're not angry, that means you don't love your country. And if you're angry like I am, that means you stand with this flag and what this flag stands for: freedom. So I'm going to read you what the state of Washington Supreme Court decision, and how they based their decision. And it says, "Washington State successfully defended its ban on the sale and purchase of large capacity gun magazines after the state Supreme Court ruled Thursday that the law doesn't violate the right to bear arms. Yes, it does. They won't admit to it, but it does violate the Second Amendment." Then it says, critical that the Supreme Court's decision was the finding that large capacity magazines, those that cannot hold more than 10 rounds of ammunition, are not arms within either the state or the United States Constitution provision. Large capacity magazines are not weapons. They are attachments to weapons and Accessories, Associated Chief Justice Charles Johnson wrote on behalf of the majority. Let me correct Chief Justice Charles Johnson on that. First of all, number one, a loaded magazine is a gun. Saying that a gun is an attachment is like saying that a keyboard should be banned because it does not align with the First Amendment. So in other words, I guess you could say the argument would be if freedom of speech is not connected with social media, then freedom of speech must be associated with a quill pen. Get the picture on that. Then it says Washington legislators enacted Senate Bill 5078 in 2022, prohibiting the manufacture, import, distribution, or sale of any large capacity magazine within the state. The magazines are defined as any ammunition feeding device capable of accepting more than 10 rounds. In late 2023, then Washington Attorney General Bob Ferguson, currently the governor of Washington, sued Gators Customs Gun, a gun shop in southwest city of Kalesko, and its owner, Walter Wentz, for continuing to sell high-capacity magazines. Wentz County Superior Court sided with the gun shop in April 2024 and declared the bill factually unconstitutional. Though the Washington Supreme Court issued an emergency stay barring the Supreme Court ruling from taking place until the High Court reviewed the case. While the gun store argued that the large capacity magazines are subject to Second Amendment protections because they are a critical function component of a firearm, and the lower court agreed, the Supreme Court wasn't convinced. Senate Bill 5078 regulates only large capacity magazines that are capable of accepting more than 10 rounds of ammunition. And Gators admits that no firearm requires a magazine of this particular capacity to function, Johnson wrote. Thus, the large capacity magazines are not required for a firearm to function. The Supreme Court reasoned that the three factors contribute to finding that the large capacity magazines are not protected. They are designed as weapons. They are not traditionally or commonly used for self-defense and purchasing them, that this is not among the additional rights essential to enjoying the core right of bear arms defense. These judges need to go back to law school and read the Constitution. I'm sorry. They should get their license revoked to practice law. This goes to show you how fraudulent these judges are. Then it goes on to say the trial court logic in determining that the magazines are arms and therefore large capacity magazines are also arms was problematic, and the High Court found. And again, as I mentioned, a loaded magazine is a gun. The gun itself is just the shell, but the magazine is the gun. Because without a magazine, a gun cannot be a gun. First, we have never held that magazines are arms, and that the fact that a semi-automatic weapon will not function as intended without the ones that does not considerably establish that they are, Johnson wrote. Additionally, just because one instrument in a category may be afforded constitutional protection doesn't require all instruments in that category to enjoy the same protection. Provocations, whatever the word is, Johnson founded. Allegedly, that the fact that the government could not ban neither class of firearm components without comparing the right to bear arms does not mean that the government is not permitted to restrict specific subclasses of that component, Johnson wrote. Wrong again. As the Second Amendment says, the right to keep and bear arms shall not be infringed. But again, this is an activist judge that shows they're biased. Even if the court determined that the large capacity magazines fit the constitutional definition of arms, the components would still fall outside the protection of the right to bear arms because the previous protect only weapons that are commonly used for self-defense. We have been presented with no credibility and specific evidence or argument that are commonly used for such a purpose, Johnson wrote. The gun store presented the court with ownership statistics to show that the magazines are commonly used, but the High Court noted that the data doesn't support the argument that they're commonly used for self-defense. It is clear that large capacity magazines are attached firearms in order to increase ammunition capacity above 10 rounds, and there is undoubtedly a combat purpose behind the use of firearms, Johnson wrote. Plus, the ban still permits individuals to own and operate and maintain proficiency with firearms, as there are no firearms that expressly require a large capacity magazine to function. Unlike ammunition, which is necessary for firearms to operate or else be rendered a paperweight or scarcely effective a bludgeoning tool. Semi-automatic weapons can still function with a magazine that falls outside the law's restriction. While the Supreme Court found in favor of the state on the constitutional challenge, it declined the state's request to reassign the case to a new judge on remand. Cowlitz County judge legally errors in the finding of the bill are unconstitutionally weren't enough to warrant to the reassignment, and even though the record reflects that the judge's strong feelings as to the constitutionality of the law. Dissenting majority Supreme Court Justice Gordon MacLeod argued that the Second Amendment protects more than just imminent objects like firearms or magazines in isolation, but rather to conduct the bearing arms in self-defense for legal use. MacLeod noted that the hard images of the Second Amendment firearms fulfilling the key purpose, including the purpose of self-defense without a magazine, in contest between the state statute and the United States Constitution. The judiciary branch has a duty to uphold the Constitution, MacLeod wrote. This is true even in the portion of the Constitution as it issues at the Second Amendment. Well, there you have it, folks. And again, these judges are wrong. 100% dead wrong, except for this one judge that made it clear that high capacity magazines are firearms. Now, I've gone through this argument before with numerous anti-gunners in a debate. There's this one punk kid who asked me, why do you need a 30-round magazine? Because it's my constitutional right. What's the point? There doesn't need to be a point. I don't need to give you a point. The only point you need to know, it's my constitutional right. Just because you don't like something doesn't mean I have to live by it. Just because you don't like me owning 30 rounds doesn't mean I should respect your wishes. It defeats the purpose of us being a free nation. That is the purpose. Whether you like 30-round magazines or you don't like 30-round magazines, whether you like 15-round magazines or you don't like 15-round magazines, a constitutional right is a constitutional right. And you cannot infringe upon a constitutional right. Pure and simple. And this argument is already made in Hellard versus Washington, D.C., and this argument was also made in McDonald versus Chicago. Now, under Hellard, the state of Washington banned, the nation's capital, Washington, made it difficult for Dick Hellard to own a firearm. They made him pay all these fees. They said that you cannot have this magazine, this gun needs to be registered, or that gun's registered. So in other words, Washington, D.C. picks and chooses what guns you can own and what you cannot. And Hellard stood up to the establishment back in 2008, and the Supreme Court ruled in a 5-4 decision, though it should be a 9-0 decision, but you have 4 activist judges on the court at the time. But one of the notable judges was the late Anthony Scalia. Scalia argued that, first of all, number one, that a gun cannot be a gun without a magazine. No more, no less that a revolver cannot be a revolver. So in other words, if magazines, high-capacity magazines, should be illegal in Washington, what about a revolver cylinder? Let's say if we made a 10-round revolver cylinder, well, usually technically a revolver can hold up to 8 rounds. But let's say the Supreme Court Washington says, no, you're going to only need a 4-round cylinder. That would be baloney. That would be total BS. And not only that, Judge Anthony Scalia also ruled in McDonald the same thing as he said in Washington, D.C., in the Washington, D.C. case of Hellard versus Washington, D.C. He also ruled in Chicago versus McDonald that you don't infringe upon a constitutional right. Now, one of the lawyers for Hellard, not for Hellard, but for Washington, D.C., and a lawyer for Chicago made this lame comparison saying, well, you register your car, how come you can't re-register guns? Well, there's a big difference between that. First of all, number one, driving a car on public roads is not a constitutional right, it's a privilege. It's a difference between privileges and constitutional rights. You don't register a constitutional right. No more and no less that you don't put a polling tax every time you vote. It's pure and simple. Any moron can figure that one out. You don't put a polling tax on your right to vote, and you don't put a fee or any type of registration on a firearm because it defeats the purpose of it being a constitutional right. That is why it's called a constitutional right. And I'll repeat that again. That is why it's called a constitutional right. And the attorneys, when they heard that, they were stone-faced. They were lost for words. And then Anthony Scalia asked the attorneys from Washington, D.C., how long have you practiced law? And the attorney for Washington, D.C., and even the attorney for Hellard, or for the city of Chicago, when Otis McDonald sued Chicago, one said, oh, I've been practicing law 30 years. The other one practiced 25. And then Anthony Scalia looked at him. He slowly took off his glasses. You mean to tell me you've been practicing law this long and they didn't teach you that in law school, a difference between a constitutional right and a privilege? I mean, Anthony Scalia made those lawyers look like a bunch of idiots. But here is a judge that will disagree with the judge in Washington, D.C. Now, excuse me, not Washington, D.C., but in the state of Washington. California Ninth Circuit Court, Lawrence Van Dyke. He did a demonstration on firearms. Lawrence Van Dyke, who is a Ninth Circuit judge and a true rule of law judge, he basically goes by the Constitution. And one of the things he says that a magazine is aligned with the Second Amendment because it's the lung of the gun. And as I've said before, a loaded magazine is a gun. A loaded magazine is a loaded firearm. A loaded magazine is a gun. No more and no less than a loaded cylinder is a revolver. A cylinder is a revolver and a magazine is a gun because they're connected to each other. It's the organ of the gun. And I encourage you to watch Judge Van Dyke's argument. You can look it up on YouTube and see how he embarrassed his colleagues who were one of these activist judges who have a bias towards the Second Amendment. Well, that is it for today for WYO28 Arsenal Roundup News. If you have a unconstitutional law that's happening in your state, if you have a bill that relates to Second Amendment rights that's coming up in your state, you can email me at rjespinoza, that's ESPINOZA, rjespinoza.roundupnews@gmail.com. Tell me what state you're from. Tell me about the legislation bill. Will it benefit your Second Amendment rights or will it affect your Second Amendment rights? Tell me the names of the sponsors of the bill and tell me what you want done and what you're willing to do to stand up to the bill, whether if it's a unjust bill or a bill that will protect your constitutional rights. Tell me about it and I will be sure to broadcast it in my next podcast. Well, that is it for today. And until then, be armed, be safe, be vigilant, protect your home, protect your loved ones with a firearm, because that's what the Second Amendment gives you that right. And remember, it's just not about guns, it's about freedom. It's about freedom and the flag behind me. Have a great night.